Hello, welcome to the Law Professor. In this video, we'll be looking at dissolution of marriage, and we are looking at one of the elements for dissolution of marriage: willful and persistent refusal to consummate the marriage as an element, as a fact for the dissolution of a statutory marriage in Nigeria, as a fact for dissolution of statutory marriage in Nigeria. And what are we talking about? We are looking at this, like I said, because in Nigeria, we have established the fact that there are different systems of marriage, and the statutory marriage represents one of these systems. It represents one of these systems. The Matrimonial Causes Act of Nigeria governs dissolution of marriage. Matrimonial Causes Act of Nigeria covers dissolution of marriage. And in this respect, we are trying to understand the meaning of willful and persistent refusal to consummate a marriage as a learning outcome. We are also trying to develop competencies to be able to apply to case scenarios, so that when you see a case as a student that deals with this issue, you'll be able to identify and apply the relevant rules. The relevant section is section 15 of the Matrimonial Causes Act, which deals with the concept of irretrievable breakdown of marriage. Irretrievable breakdown of marriage. And what are we talking about here? The section 51, says that a petition under the Matrimonial Causes Act by a party, any of the parties, husband or wife, for a decree of dissolution of the marriage may be presented upon the fact that the marriage has broken down irretrievably. So if anybody were to ask you what is the basis of petitioning for dissolution of marriage under the Matrimonial Causes Act with respect to statutory marriage, then you say that it is the irretrievable breakdown of the marriage that is the basis. Now, if you go to section 15.2, it now provides that to establish irretrievable breakdown of marriage, you can apply any of the facts from subsection A downwards. And the first one we are looking at is the issue of willful and persistent refusal to consummate the marriage, where you can demonstrate that in your petition. And that petition, like I said in previous presentations, is brought before the High Court of a state, when it comes to statutory marriage. The consummation, what we are talking about with respect to consummation, means that the person has failed to have sexual intercourse with the partners since this marriage was celebrated. Whatever sexual intercourse took place previous to the marriage is not countenance. Since they got married, as there be consummation, as there be sexual intercourse between the parties, that is a relevant issue. And the word willful in that provision is interpreted to mean intentional, deliberate, voluntary. If somebody has been kidnapped the day they got married, for instance, you cannot say the person has willfully refused if it's not available. If a person has been incapacitated, it's not a question of willful. It may come under another provision of the MCA, but not a willful decision. Intentional, voluntary action of refusal. And in hurting and hurting, the court said that the person must have decided, settled, and come to a definite decision that they will not consummate the marriage. They will not have sexual intercourse with their partners. Whatever may be the reasons, it's another issue. It may be through any consideration that may arise in the course of the evidence. So the issue of persistence requires that you the issue of willfulness requires that there is a positive decision not to have sexual intercourse with a partner. And you can see it being exemplified in Baxter and Baxter, where the court said that, look, if the wife is a bit shy and timid and, not really amorous, it is the responsibility of the husband to draw her out of that limitation. And that cannot be said to be a willful decision. So when you have someone that has neglected, not consider it important, that may not be a willful decision. And then persistence means that it is continuous. You have made a request for sexual intercourse. The person has persistently refused to comply with the request. So if you look at that, it means that there must be some period for request and opportunity to respond to the request. And so when you combine willful and persistent, it means that a refusal to consummate has taken place despite the fact that there has been repeated requests, there must be no just cause for the refusal. Like we said, because it is expected that the refusal is intentional and deliberate, there may be just reasons why someone may not have sexual intercourse. What if there's extreme ill health, where the person may not be available? The person may have been sent on an assignment immediately after the marriage. It may be a conditional demand. The person may have provided or made some requests, a condition precedent before they can have sexual intercourse. Maybe, for instance, you have refused because, you are not in a position to grant the request. Take a case like Jodler and Jodler, because the spouse said that there must be contraceptive use. The court said that is not a refusal to consummate. Fourth and fourth, where the man was unable to have sexual intercourse because he was in prison. He was incarcerated at that time, and having sexual intercourse would be against the regulations of the prison. The court said at that moment there was no willful refusal to consummate the marriage. But when he persisted in refusing consummation after he was released, then that was the time you begin to count that there has been a willful refusal to consummate a marriage. So you can actually begin to experiment with the question within your mind as to what are the other ways in which someone may have a just cause for refusing to consummate the marriage. The court requires that when you are bringing your application on this ground, it must be established that as at the time of the proceedings, the marriage remains unconsummated. So even when you have filed the petition and then subsequently the person consummates the marriage, you will be unable to bring your petition on this ground. Section 21 of the Matrimonial Causes Act therefore demands that the non-consummation remains an ongoing process. In summary, therefore, a statutory marriage celebrated under the MCA may be dissolved where it has broken down irretrievably. One of the grounds establishing irretrievable breakdown of marriage is in section 15(2)(a), which says that failure to consummate, which is willful and persistent, establishes the fact that the marriage has broken down irretrievably. It is we are not sure of the number of requests or the period or the interval that you need to show that we show that there's been persistent refusal. In the facts of each case, we determine that the word willful has been interpreted to be intentional and deliberate and voluntary actions, a conscious decision with your full mind and faculties intact that the person will not consummate. And persistent could know that there has been requests and the person has continuously, repeatedly refused to honor the request. The willful and persistent refusal to consummate the marriage must exist at the time of hearing the petition for dissolution of marriage. In the next presentation, we'll be looking at the second fact of breakdown of marriage. I hope that you have subscribed to the Law Professor, where we hope to bring you many of the issues that you experience both in the learning the law and in also practicing the law. Thank you.